Welcome to the Demidchik Law Firm YouTube channel.
What are the differences in bail rules between federal and state cases, and how do these differences affect the case? Anna.
Right. So federal cases and state cases are quite different, also in regards to bail. I have to say the two components of a successful bailout are still the same. It's really how they're applied and how they play out in practice is what makes the difference. So the two components are, again, it's important for the defendant to show that he or she is not a flight risk, that the defendant is going to show up to court again, all the way through the court adjudication. And component number two, not a danger to the community. In the federal case is, for example, that the federal cases have a certain presumption for detention, presumption of detainability. And that would be crimes that have to do with drug trafficking or with terrorism. The charged offense has to do with any of those things. The judge is going to essentially presume that there should be detention, and it's going to be on the defendant to argue why they should not and to offer all kinds of alternative means. With the state, also, it goes by the type of a crime. Usually the violent crimes are the ones where people get either held on high bail or denied release. Also, something like a person's mental health issues could actually be an adverse factor in a state court. So in the state court, bail hearing generally takes place very quickly, within the same 72 hours from the arrest. And it's usually happens at the same time as the arraignment. Now, you would think it's a good thing because you get your determination of how much the bail will be, or if there is a release on the recognizance, but not necessarily. Again, depending on the case, sometimes it makes sense to postpone that hearing to prepare a better argument for a release. Because problem is, once the bail is set in the state court, it could be very difficult to change it because a change of circumstances would be necessary to rework the bail numbers. So if there's a danger that the bail may be set high and the person cannot pay it, then maybe it's better to postpone the argument. Now, in federal court, bail hearing generally does not happen for about a week, which really makes sense because federal court is it's much more thorough court. And the bail packet is usually required to be pretty thorough. There's just more to prove up front with the evidence you have to put together. Even for the ankle monitoring, like you have to, for example, provide proof that the person has a lease and the apartment has a place to stay and that place has a landline or it will be connected to the landline. All of these things have to be provided to the court in order for the court to consider bail. Also, I would say in federal court, another part that is rather important that I've seen in my practice, curiously, is that a person's behavior before the detention matters a lot more because federal cases usually are investigated very thoroughly before the government brings them. Contrast that with a state case. In the state case, the mechanism is there is a complaint, very little investigation, and then the case is brought to court. So everybody realizes that there may be some mistake, there may be mistaken identification, but the chance of the person being either innocent or not guilty as charged is much higher compared to the federal court, because in the federal court, a lot of investigation takes place. And usually federal cases are not brought unless the prosecution, right, the US attorney, is quite sure that there is evidence to convict. And so what I've seen happening with some of our clients, and also in other cases that I just read for educational purposes, is if a person behaves suspiciously during an investigation stage, and that gives the government a reason to believe that the person is a flight risk, well, in that case, the government can argue that bail should be denied or bail should be extremely high. And it would just, we've had a case where we were actually unable to get the client out because the government made a good argument that the person acted like this person would be flight risk during the investigation stage. So handling the investigation stage in a federal criminal case is extremely important. I think I'll make a separate topic on that actually, because it can make a huge difference between how many years in prison and a lot less than that. So one more thing I want to touch base on specifically for the viewers of this channel is how being born in another country affects bail outcome, both federal and state cases. I would say in the federal case, being born in another country is scrutinized much more because usually the government has access to the databases to verify not only when the person came here and how the person came here, but also where they have been frequent trips to their home country. Because their main concern is that, for example, if someone is not a citizen or has a second passport, then once on bail, the person just picks up and goes away, right? So if the person picks up and goes away, and even if they hold your passport in custody, they tell you to turn in your passport, the concern is that a person might just go to the consulate, right, and get another one. So federal government is usually much more attuned to this. And so it's important to make an argument why a return to one's home country is not going to happen. In the state courts, sometimes the question does come up, but I see it a lot less frequently, only on like the higher charges, I would say. On the lower charges, a lot of times nobody even bothers. So I would say in state court, a lot of times making an argument that someone is here in lawful status or figuring out their lawful status, it's actually even a more beneficial thing to make this argument, because then you can say, look, my client knows that skipping and not coming back to court will forever cancel their dreams of becoming a green card holder or a US citizen. So they will definitely show up. All right, in federal court, it's a little bit less of a winning argument.